if I could have your attention, our heartfelt thanks to Bomchil and also to MHR for the wonderful luncheon that you've already enjoyed. But what you are about to see coming up is not just a luncheon interview between two giants who are close friends of each other, close friends of ALARB, close friends of the ITA. This is also the 28th installment of Preserving Perspectives, which is a project of the ITA's Academic Council. It records the evolution of modern international commercial arbitration in the words of those who have led it. Like many great inventions, its origin is rooted more in luck than in planning. Let me explain. At an experimental program, which was once called the ITA Winter Forum, held during the winter of 2012, the luncheon featured something that we simply called a fireside chat between Professor David Caron and Professor George Berman. And the conversation was simply electric. You had two friends, two titans, two great intellects, two of the deepest wells of experience, sharing personal stories about their journeys through our shared personal environment. We immediately regretted that we hadn't even thought of recording that conversation for future generations. The next year, the luncheon for the Winter Forum still had a conversation, still only called a conversation, between Gary Bourne and Professor Linda Silberman. At least we recorded it for posterity, but it was in the third year that a few things changed. First, the Winter Forum became the ITA, IEL, ICC Joint Conference on International Energy Arbitration, which is held in Houston in January. It has become huge. I encourage you to attend. The second thing that changed is I interviewed my father, Judge Charles N. Brower. The interview was recorded. It was posted to YouTube. Over the past 10 years or so, there have been about 1,200 views. And third and most importantly, the ITA explicitly advertised the event as the third in a series of oral history interviews conducted by the ITA's Academic Council. And that was the moment of recognition. The moment of recognition that these interviews were not simply lunchtime banter, not part of the entertainment, but part of a larger effort to honor individuals whose contributions have shaped the practice of modern international law. Subsequent installments have included Bernardo Sepulveda, Klaus von Wobiser, Yves Fortier, Lucy Reed, Meg Kinnear. I should pause to mention, and you've already seen we've made a substitution in the program, Eduardo Zuleta is unable to conduct the interview due to a family emergency, but Eduardo Silva Romero has graciously agreed to take his place. So again, we still have two friends, two titans, two great intellects, two of the deepest wells of experience in the field. Together they have sat in roughly 120 arbitrations and have held almost every important position in our organizations and in the profession. So I can recall my father's excitement when Guido Tawil first became involved in the ITA. This was at a time when I rarely saw my father exhibit excitement, but he truly was. Later, Guido co-chaired the 22nd annual workshop for us in Texas in 2010. He appeared on the distinguished faculty for our 25th anniversary workshop in 2013. He's also served with distinction for many years on the ITA's Academic Council, so it is fitting that we should interview him today. We don't see Guido as much as we used to. We miss him when he is gone.
No pressure.
But we are so happy to welcome him back and to celebrate his long and his influential engagement with international arbitration.
Thanks very much.
Good afternoon, everyone. As Chip just said, I'm not Eduardo Zuleta. Zuleta is a bit taller, as you may know. But Eduardo's inconvenient family moment gave me the privilege and the honor to interview Guido Tawil. I was told at the beginning that I could cross-examine Guido, but this information was contradictory with the type of questions that I can ask him, because I was told that only open questions could be put to Guido. So the cross-examination will be for another occasion. Who is Guido Santiago Tawil? You all know him. Guido has many faces in the profession. We know the current face of Guido, one of the most renowned arbitrators internationally. He decided to become a full-time arbitrator in 2018. We also may know here the other face of Guido. Guido is a very distinguished professor of administrative law. He taught administrative law at the Universidad de Buenos Aires, the famous UBA, for 35 years. But Guido was also the one who created the arbitration practice of a very important law firm in Buenos Aires, Bomchil. We will speak later about all the mentees that Guido has because of that role. He was counsel in many important cases, as you may also know as well. Guido has lastly intervened in many organizations at leadership roles. He is a former president and now honorary president of ALARB, one of the organizers of the conferences, such as this one. He was also, or had many positions at ITA, as Chip just mentioned, and he was a co-chair of the IBA Arbitration Committee, which, as we will discuss later, is a very important moment for Guido in his career as well. I will not mention the 140 publications of Guido, but Guido has written a lot, and I very much recommend reading his contributions to the science of law. So Guido, the first question is, what was it that drew you to the practice of law?
Thanks very much, Eduardo. A pleasure to appear in this series, and our prayers with Eduardo Zuleta and his family. What drove me into law? I would say my father was a lawyer, so my home was already impregnated by law. I always liked, since I was a child, history, politics, and I would say it was a sort of a common path. I don't think anyone that has become a lawyer knows from the beginning that wants to be a lawyer, but at the end it ended that way, and I was very happy. I would say more and more I got into the field, I like it.
And I understand you studied then in the UBA, University of Buenos Aires, and at the time where you were a student of law at the UBA, were you interested in international law, arbitration, this type of matters? Arbitration
didn't exist at that time. The Universidad de Buenos Aires never teach arbitration until probably 20 years ago, where particularly Roque Caivano started a lot with the issue. It was a small chapter in procedural law, in civil procedural law. I was interested in administrative law, as most of my partners and former students. We all came from that field of law. But what I like, and probably it's somewhat of the common ground, is I like comparative law. So I was very much into comparative law, and I started teaching comparative law as well.
which is something that you find a lot with administrative law specialists.
Exactly.
To see how other states regulate.
Yeah, it was very interesting. Actually, my PhD, my dissertation was about comparative administrative law.
Right. What do you think of a trend that we see today of younger students specializing very rapidly in international arbitration, given that you and many others, including myself, we come from other fields?
That's true. I think probably we are, my generation, certainly you are a little bit younger, although you have a great standing. But
getting older every day.
Yeah, but certainly we didn't study arbitration. We ended in arbitration. It's very common to have our colleagues say, well, how did you go? How did you get your first arbitration? Well, they ask who spoke English. I speak English. You come. In our case, we were driven by the cases into arbitration. Many people, I remember many colleagues who were doing sort of commercial banking or whatever. Eduardo was doing finance and banking. I think that, and this is an issue that it always attracted me, how to coach or how to give a message to the youngsters. And I have a sort of conflicting views, in particular because you see the competitions, everyone likes the moot competitions because of the great reward of knowing people. But sometimes the competitions give the message that there's a field of practice there. And certainly today there's a much bigger field of practice than what existed 20 years ago. But still, depending your market, you should be cautious. I mean, one thing in South America, you have a lot of arbitration in Peru, in Brazil. That doesn't happen in many other countries. Although I must say that, as an example, Argentina now has much more arbitration than it used to have. But my advice was always, you need to specialize in a field, in a sort of a core field, say commercial law, say civil law, say administrative law, and then if you can get closer to arbitration, say get into one of the big teams or with an arbitration, that's fine. But I would never say go into arbitration directly, and I always remember about something that really frustrated me is having that people that came normally from Paris or other cities saying, we have been in the arbitration circle for probably 2 years or 3 years, just moving from one firm to another one for a position as a trainee for 5 months, and the train left, and the people probably are 35, and they still are trainees. So I think there's a sort of a conflict of interest sometimes between universities and students or colleagues. Universities and us that like teaching, we need to give a clear message to that people, because if not, they are going to be out of the market.
Right. When you were at the UBA as a student, was there a professor that influenced you more than others, someone we should know about?
I wouldn't say so. Probably some authors of administrative law. It's Bullrich, Bielsa, Villegas, Bilbaso, Marinho, who was to a certain extent my mentor. I would say that really the person that more influenced me was my father first, who I started practicing with him. And then when I returned of researching for my PhD, I was called by the Argentina Supreme Court of Justice. And a justice whom I work with, Belucio, was really a person that sort of influenced me a lot, particularly on the standard of work, etc.
So your first job after university was with your father?
I was with my father. I did civil and commercial. I did everything, evictions, whatever any lawyers does.
Was it difficult to work with your father?
It was difficult. Probably it was more difficult for him than for me. As a young blood, you normally want to change everything. And he was a great guy, and he was too generous to open to a youngster that was not an easy youngster, I must say.
In the first part of your career, what do you find especially exciting about the practice of law?
Everything was exciting. I mean, everything was new. I mean, and normally solo practitioners, so I think it's extremely exciting.
Was your father a litigator or more?
He was a litigator. He had a great criteria. He probably didn't excel in other fields, but he had a great criteria. It was, I think I learned a lot about that, about taking the right decision. If I would say what is I think the most important virtue a good lawyer can have is criteria. Is take the right decisions. I mean, in arbitration you can have the great memorials, but if you don't have the right decision, I mean, it's a lot of tactical decisions, and I learned a lot about him there.
So your father was certainly your first mentor in the profession. Any other names during the profession that you...
Yes, as I said, what happened to me is I graduated probably too young. I was actually drafted by the military at the same time I was studying.
That explains how...
He had me, you suffer me as a chair of an arbitration panel board.
I have appeared before, many times, and not suffer him, but I have obeyed him as much as I could.
Well, I graduated young, then I went abroad to do my PhD. I actually sold my car, rented my apartment, and left. It took me some years to pay back the loan. And so everything that you see in the senior people is the same that happened to the youngsters. Youngsters think that all of us sort of were born in the positions you have now, and we all of us suffer the same difficulties and situations. And I would say that, as I said, Belucio was a big mentor, and certainly some of my partners at Bomchil were of great assistance in my career. You could have the conditions, but if you don't have the help and the assistance of your team and of your partners, it's very difficult.
But you became a member of Bomchil after being already a professor at the UBA. So let us know a bit more about how you became a professor and what you found important in that role, and probably you still find it.
I started at the same time. I did the two careers in parallel. I started teaching. I graduated, it's difficult to say, in 1983. That's a long time ago. And I started teaching in 1984. I started as a very young professor. I was 21, 22 years old. I remember I needed to cut my hair to appear a little bit more serious, no? Because people would say, "You're too young." Yeah, you should. You still have to.
My hairdresser was.
But I started there as a young assistant professor, as many. Then started competing for the positions, and I really enjoyed it. I must say, my enjoyment has been teaching.
How many students do you normally have in the classroom?
Probably 80.
80.
Between 50 and 80.
So it was more the professor delivering a lecture and the students taking notes, or there was some interaction?
It depends. I mean, in the first years it was more of a sort of what we call clase magistral, or sort of theoretical chat. Then you started having small courses and graduate courses. There was more interaction, but yeah, that was.
Any bad experience you can tell us?
Yeah, I will reserve the bad experience. I will reserve them, as always. I mean, the academic circles are not always easy. I would say that in my experience, anything where you have individuals involved are tougher than when you have companies. That's why it's so passionate. No, if you have, as an example, public employment, there's a lot of harassment there. If you have competitions, teaching competitions, they are tough. Here in Argentina, everyone ends in the judiciary and challenging each other. It's quite nasty sometimes. But I was fortunate enough not to have those situations.
Yes, I mean, many people say that politics in universities are worse than in law firms. So we can draw conclusions from it. So then you joined Bomchil, and you became the head of the administrative law practice, the head of the international arbitration practice. How did it happen?
I left the judiciary. I was a secretary of the Supreme Court, and then I moved to the what we call in Argentina our SEC, Securities and Exchange Commission. I was a commissioner of our SEC. I was there for 2 years, and then I entered as a partner of Bomchil. Actually, my first arbitration came through my position in the government.
Right. And so you built the practice at Bomchil, especially from investment arbitration or commercial arbitration, both?
Yeah,
how did it?
I actually, as I left from the Securities and Exchange Commission, I entered Bomchil to do commercial law, not administrative or of arbitration. Nobody was doing neither administrative law nor arbitration, and we built the practice. And we were driven into arbitration through investment arbitration. It's quite unusual. And we actually didn't do arbitration in Argentina, but we do arbitration abroad. Normally, the normal path is you do commercial arbitration domestically and then move abroad. In our case, we came from
both.
Actually, many people in Argentina didn't know that we knew arbitration, and many people abroad didn't know that we did administrative law.
Right. Do you ever doubt about practicing law? Do you ever consider I don't know, having a different profession, or being a specialist in motorcycles or something like that?
As everyone, I think in the bad moments you say, why I'm here? What am I doing? No, I think we were very fortunate. We had great people, great team, great cases. We had a wonderful life, and I think that it could not have been better.
So you have changed positions in your career. You told us you were a leader in a law firm, a professor, counsel, and now a full-time arbitrator. There are transitions in a career. How do you manage those transitions? That's something which is, in my view, not easy.
That's true, but probably being an Argentinian, Argentina has had so many transitions. We have had to adapt to so many situations that you're bulletproof. I mean, and particularly my work in the Supreme Court also showed me that you could address any issue if you do it with calm and you start doing it step by step. So I think we could manage it. Looking forward, moving forward, and being brave. I mean, the first time we did arbitration, we had never had an experience. We were lead counsel in some cases.
Yes. Well, the Siemens case.
The Siemens case and some others. Yeah.
Some other cases. Guido, your daughter Agustina is now a lawyer. I understand she's working now at Bomchil. What advice, if she accepted, would you like to give to Agustina before all of us?
Yeah, we're extremely proud of our Agustina. I'm sure Agustina is gonna be a great lawyer, and we're extremely proud of all our children, of course. I think that, as you say, Agustina doesn't like me to advise. I mean, she says, "You are not my teacher, you are not my master, you are my father, so forget about it." Sorry for that. No, I think to all youngsters, I mean, if I have to say what I have learned in life is, you need to project what you want to do. You're going to project and go and you think you're going to go one place and you're going to end in a completely different place in your life. But the exercise of thinking ahead, at least for our generation, has been crucial.
Which of your professional accomplishment is the most important to you?
Being chair professor of university. That was what I certainly enjoyed much, and if I have to be proud of something, I would say that one.
And what was the biggest challenge so far in your career?
I think that the challenges come normally with situations you have gone through when you manage sensitive cases and you have some pressure. Probably if your cases have become public and you have media, and those are difficult situations, but it's part of the game. I mean, all of us have suffered that, and we need to deal with that. It's part of the profession.
Let's turn, if you will, to questions more related to arbitration, which may be of interest to the audience. You were chair of the IBA Arbitration Committee. You are a member of the governing board of ICA, founding member of ALARB, and you held, as we said, various positions at ITA. What have you found more interesting about your contributions in those institutions, especially towards international arbitration?
I think it's a fantastic experience. If I have to give an advice, is enter these institutions. And probably the main lesson you get there is how the systems integrate. This sort of particular blend of people that you get to know, and how at the end there's a blend there's a culture that it's a total blend. I mean, I had great experiences working together, as you did. You were also co-chair of the arbitration committee, and you were Secretary General of the ICCA.
Thanks to you. Guido appointed me to the arbitration committee.
It was your merit. But what I say is, it's amazing the experiences one obtains working together with people of different cultures. You lead with Josema and others an international team. It's fantastic. Your team, you have people from your country, you have people from Africa or from Asia or whatever, and it's fantastic how you get to a common understanding and a common work. It appears to be from the beginning so different, but international arbitration has achieved, and the arbitration committee of the IBA has been crucial to that, people before us, of course, to be able to set a common standard and a common playground. I think that's fantastic. Even though there's a lot of criticisms against arbitration, what arbitration has achieved is unique, and we should be proud of it.
There are a couple of more or less personal questions here, which I find interesting, so I'll ask them, and then we can come back to the field of arbitration more generally. One is, having acted as counsel and arbitrator, what is your favorite case that we can know publicly?
As counsel, I would say my first one and my last one, due to the experiences. In our first one, I was actually, I just left the Securities and Exchange Commission. Many people don't know that, but I was appointed by the government of Argentina to represent Argentina in 2 cases together with Francisco Gutierrez, who's here, and we had a great experience. We needed to prove to 2 different tribunals, exactly the same cases, one under Argentine law and the other under Swiss law, that the Argentine hyperinflation was not something unprevisible. And it was amazing.
Interesting.
And we were able to do so. And it was fantastic because Francisco at that time found that the Swiss Supreme Court had a different translation between the French and the German decision. The different translation had a different meaning, and the case was decided because at the last time, at the last moment of the hearing, through how would you say, una lupa, a magnifying glass, we found that thanks, Josema, very useful. We found that one of the documents were forged. And that was fantastic. We never had done arbitration of any kind, and we were appointed to have a big construction law. And ICCA, actually, Fernando Mantilla was the counsel at the ICCA at that time. That was 1993 or 1994.
Yeah, he was.
And I would say the last ones, because were the last cases with our team, with Marinés, with Santiago, with many others, and it was a fantastic experience to see how the teams have been able to develop. I mean,
as an arbitrator?
As an arbitrator, I would say different cases as well.
All investment cases, or
no, investment and ICC cases. We had some difficult counsel in some cases.
A counsel simply defend the client's interests.
Of course, no, and they do it great. I was joking. It has been fantastic. Different cases. I would say if I have to give names of cases, investment cases are cases one can mention. I would say Charani, Solux, Garcia Armas. There are many Pacific Rim, where we had very interesting tribunals, and in particular the possibility of sharing with people with such amazing people. I mean, we are privileged to be able to work and find this extraordinary counsel and arbitrators.
There is a book that has been relied upon many times to speak about the sociology of arbitration. This book, you recall it, Dealing in Virtue, which many years ago described different models of how to enter into the field of arbitration. I recall there was the LaLive model, so the professor, very distinguished at the university, the Paulson model, called at the time the truly international model, and then the DeHaan's model, because he was at a very prestigious institution and through it entered into the field. I do have the impression that the world of arbitration has changed a lot since, and it would be interesting to hear from you, Guido, how you see it.
No, I agree. I don't think there's a single mode of getting into arbitration. Each of us have arrived in different ways. What is true is that years ago it was a fencing, a sort of a gentleman, I would say gentlemen and women, but a sort of a very sort of a fencing exercise, no? And now it's a little bit tougher, and that is probably, even one probably doesn't like part of it, it's a result of the success of arbitration. Arbitration is a real way of deciding disputes, and what has happened is many people have come and continue getting to arbitration, and not all practices and not all ways of dealing are the same. And that's something we need to address and solve.
What is your take on the situation, the state currently of investment arbitration? You act a lot in investment cases, and you may have a sentiment of whether or not this is going somewhere at this moment.
Yeah, let me put it this way. As administrative lawyers, all of us have dealt with the government forever, either working for the government or working in cases not with the government. We know how governments work. And I think that in the case of investment arbitration, there's a sort of a questioning of investment arbitration in which I personally don't agree. I think that the system works, and anyone that gets into the system realizes that it works. It has the same faults and the same problems that courts have, but nobody has said, let's get rid of courts. I think that we need to address it, and the problem is that the stakeholders of the systems don't defend the systems as they should. They should stand up and say, okay, if there's an issue, let's work with it. But we need to defend the system. Because what's the alternative? Are we going to, as Philippine Sol said many years ago, are we going to get rid of investment arbitration? What's going to happen? Are we going to go back to the gunboats diplomacy? We need to address the issue, and we need to solve the issues within international arbitration. And I think that has not been the case. And I think that the same way that developing countries have been questioned for many years due to the Calvo and soft Calvo clauses, developed countries have not meet their standards that they should have in defending the system. When they were sued, instead of defending the system and saying the system works, they just didn't. I always say that Mexico had, with Guillermo Aguilar, Hugo Pérez Cano, and many others, have got the right approach. The right approach is I have 20 cases, I win 18, I lose 2 cases, that's fine, the system works. The US should have won the Lowood case. Sorry for being so blunt, but I mean,
we know the criticisms from states against the system, and we may agree or disagree. I hear more and more critiques coming from the investors against the investment arbitration system, in the sense of saying, in order to get some remedy, meaning damages, I need to overcome jurisdictional objections, inadmissibility objections, then I need to reach the threshold to have international responsibility of the state, and there are more and more obstacles in the system to get that protection, to get that remedy. You have rendered some dissenting opinions in the system. I want to link the two questions. Is this critique correct from your perspective? How do you see it?
No, I don't think it's correct. I think it's a system. You get into a system, you know it works that way, and you need to overcome different hurdles in order to reach it. And there's a particular sensibility when you have states, that's fine. But within the system, everything, out of the system, nothing. And concerning dissents, my view is, probably because we come as Latin Americans from a system where dissents are part of our culture, not as many people outside of the region. And I think you should dissent if you don't feel comfortable. You should act with your conscience. There was an advertising many years ago here in Argentina where a bank said, your main capital is your good name. Remember Banco Rio said, I strongly believe on that. You need to honor your name, and if you consider you need to say something, you should. You know, I had a case where even as a chair I dissented.
I do recall it, yes. It was a very reasonable dissent, if I may say. So, the other question regarding investment arbitration is about the philosophy that the arbitrators intervening in those cases seem to adopt. There are some that consider that their decisions need to take into account the system or create some type of case law or jurisprudence. I'm thinking of Gabriel Kaufman-Kohler, for instance, who has expressly said so in some decisions. And then you have others who consider that the role of the arbitrator is to settle the case, which is being given to the arbitrators. I think of Charlie Brouwer or Michael Riesman, or even, curiously, Brigitte Stern. She has said that expressly. I don't know why, but
that's not.
It's black and white. What is your take on
that? I'm with Charlie, and I think we decide cases. Probably that comes from my period in the Supreme Court, where, curiously enough, our Supreme Court was, you should say exactly what you need to decide the cases, and no more than that. I don't think we should, we are not creating law. I think that if you want to create law, you write doctrine or whatever. And I think that we're designing a case, and you should be particularly cautious because of what could be transferred to future cases, particularly in investment arbitration. I remember discussing a case where, normally it's discussing among the tribunal. If we're going to say this, it's totally unnecessary, and we could making a big issue on this.
Yes.
Sorry, going back to dissents for a second. Dissents should be cautious, should be elegant, should be short and to the point. I don't like those big dissents or long dissents, those dissents of 150 pages. I don't think that's elegant, and we need to keep on that side.
In investment arbitrations, coming back to the philosophy point, you have noticed, no doubt, that the council spend a lot of pages, a lot of time identifying previous cases, trying to create the idea that there is a rule of law that could be taken out of those cases, and trying to convince the tribunal that you need to apply the same rule or not, making a distinguishing exercise. What value does that exercise have? Because if we are not in a system, but simply in the resolution of a specific case, previous decisions are not that important. Maybe we shouldn't spend that much time on it.
I don't know. I come from a legal system, the Argentine legal system, where you don't have the stare decisis, and you don't have this sort of case law as a present so relevant. I think that in the case of arbitration, it's relevant to understand what people are saying and to see if they convince us. But it's only a convincing argument. I don't feel that I'm sort of binded by other tribunal. They could be wrong. I could be wrong as well. I don't think that's the case.
Turning to another topic, there is a lot of discussion, as we know, about time and cost in international arbitration. I think we have all witnessed many new ideas that arbitrators and the council have to improve the system from that perspective. What is your take on what a full-time arbitrator could do to improve the system?
I think that we need to do is order the proceedings. What I see many times, and I have encountered that as counsel, is sometimes arbitrators are too passive, and incidents that could be avoided or not. That's why we work with ICCA in a committee some years ago with Avi Cohen and created what is called the Guidelines of Standards of Conduct. And that's related not only to cost, but to behavior in arbitration. And I think it's relevant because sometimes the cases get a little bit out of hand.
Is your impression that today counsel are more aggressive, that the arbitrations are becoming more difficult, more challenges?
They are, and sometimes it's incredible. I just heard about a case where one colleague was challenged because it embraced another one at a conference 6 seconds instead of 4 seconds.
Well, 6 seconds.
It's too much.
I don't know.
Okay, I'm sorry.
4 seconds.
No, but I mean, certainly, and again, that's part of the success of arbitration. You have a lot of people getting into arbitration, but it's also again for tribunals who try to order a little bit, because if not, it's going to be out of hands.
There is always the risk, this following risk. We have the success of arbitration. We feel that at times the system derails, but we don't want the states to get near to the system and legislate. How to do it? Is it more soft law? The IDA, ITA should become more vocal about all these
the problem with soft law, and both you, I, and many others have worked in the soft law, and we are very happy and proud of the product, is that there's already a lot of soft law. So I don't know if we can put more soft law, but certainly we could dialogue a little bit more. We could call the stakeholders and try to express a little bit more of the problems of the system. I know Andres is doing that in UNCITRAL, but as an example, the ICCA or ICCA, I have suggested many times, let's go do sort of small forums to discuss some issues and see how we can solve them. Because all of us are truly interested in the success of the system. I don't think anyone want to get rid of the system.
Speaking now about the future of arbitration, of international arbitration, what is your prediction about the future of international commercial arbitration?
I think international commercial arbitration has a good health and would stay as it is. My only question mark is how artificial intelligence will impact this. What's going to happen? We were recently in the academy, in ICCA Academy in Peru, and Ignacio Minorini, who's here present, showed me some of the software existing today, and it's amazing. I don't know what's going to happen. Fortunately, we're going to see it a little bit probably from out of the picture, but I don't know if even advocacy is going to be the same.
There are already clients requiring counsel to use artificial intelligence to be more effective and less costly. So,
and even in ITAFOR, a Fora created by ITA, some years ago there was a discussion of someone saying, well, what do you think about having a sort of artificial intelligence deciding cases? And they got into that. I said, no. I mean, we have an element that at least artificial intelligence doesn't have it, and it's the perception. It's not, but I don't know what's going to happen in 20 years' time. Very difficult.
Very difficult question. I guess some ethical decisions will need to be made, and what kind of justice humans would like to have for humans.
Yeah, but that's a key issue.
What about investment arbitration? We already spoke a bit, but...
I think investment arbitration will also be here in 20 years' time, probably in a different way, but it's going to be here. I think that it's for the, as I said, stakeholders and all of us intervening in investment arbitration, trying to solve the problems or the questioning of investment arbitration the same way that you do with courts. Nobody wants to get rid of courts. You need to solve them. If there are defects, the defects are in the people. But I certainly am a very actor in the system, either as a counselor or as an arbitrator. The system works.
It works. Then the perceptions...
Yeah, but we need to deal with the perceptions, because if the perceptions affect the system, it's awful.
I agree. Last question, because time is running. What advice, Guido, would you give law students or young professionals who want to enter into the international arbitration field?
To follow their instinct, to follow their path, whatever they want to do, to be cautious in knowing their market, to understand what is the market, first, as I said before, to specialize in a field of law, and then if they want to get closer to an arbitration team or an arbitrator, to do so. I must say, because I wrote a blog in Kluwer some years ago about the issue called The Unwitting Victims of Arbitration Success. The difference from that time today, if you go to an arbitration conference where you have 500 people, 10 years ago, 15 years ago, only 50 people were doing arbitration, 450 wanted to do arbitration. Today, almost all of them do some arbitration. So arbitration has really expanded, but they still need to know the market and be cautious.
Well, Guido, thank you very much for all these responses. The true questions will be asked privately in a way of a cross-examination, as we agreed. And let me thank Chip and the ITA for this opportunity.
Thanks very much. Thanks, Chip.